Right. Thank you so much. It would be really helpful if more of you could turn on your cameras. That would be great. Please don't worry about looking presentable. That is fine. We understand that it is late in the evening and we all have plans. Uh, right. Thank you so much for joining in today's session. So let me quickly introduce our speaker for today, Miss Komal Dubey. Uh, Komal is a corporate law professional with over 13 years of experience that she has gained over advising companies, LLPs, startups, and business leaders. She heads the corporate law and compliance practice at Sharma Kemp Chambers, and her work here at the Chambers focuses on advising domestic and international clients on a broad spectrum of corporate and commercial legal matters. Today, Ms. Komal will be walking us through MoA and AoA and how legal compliance around these two topics, very important topics, function in practice. So I hope you all are very excited about today's session and I hope you find it fruitful. Uh, Komal ma'am, now over to you.
Yeah. Good evening, everybody. Thank you so much for this opportunity. I would just share my screen one sec.
While Komal ma'am is sharing her screen, please let me quickly tell you a few sort of house rules that we have. Firstly, there are no correct or incorrect options or answers. We would want you to be as participative as possible. Secondly, um, see, at the end of the day, this is a practical learning session. So we would encourage you guys to ask as many questions as you can because it is ultimately going to benefit you. Thirdly, if at a slide you feel there is a question that you have, I would advise you to please wait till the end of the slide to ask your question so that sometimes what happens is our questions get clarified by the time we complete the material on that particular slide. This also, helps sort of organize our questions. Sakshi,
Yes, sir.
just a quick question. Um, have we reserved some Q&A time towards the end?
Yes, sir. That will be better because all the
All
questions will
right.
be answered at that time.
All right, perfect. Right. So, guys, please reserve your questions till the end of the session when we have the dedicated Q&A rounds. I hope you find this session helpful and you really enjoy it. Thank you.
Yeah. Is my screen visible?
Yes, ma'am.
Yeah. So, coming to the major question, what an AoA or an MoA is? Yeah. Uh, any company that you pick up anywhere, there are some constitutional documents that come around along with the company. And these constitutional documents act like the main document of the company to understand how the company works, what the company would do, how would it proceed with its procedures, what would happen in case if there are borrowings, in case if they want to buy any asset. So these are the major things that are placed, not just these. Apart from that, even regulatory things like in case if there are in case if there is a meeting, what the quorum should be like. So even intricate things like this. In case if there are registers in the company, where should it be placed? Even smallest thing like this. So everything is recorded, everything is placed already with the company, and so how does it work? Has anyone gone through an MOA or an AOA of a company before this session? In case, just show me a thumbs
No,
up if
ma'am.
you have. Okay,
No, ma'am.
nobody, is it?
Um,
Okay.
AoA. Wait a minute, ma'am. Here, the AoA
Yeah.
you are referring to articles of association.
Yes.
Okay.
So MOA would be the memorandum of association, and AOA would be the articles of association. Okay. Okay, so let's just head start understanding that the audience does not know anything about it, and this is the first time we're getting into it. I just hope that I bring justice to the whole thing. So this is going to be the roadmap of the session. We understand what corporate constitutional documents are, what an memorandum of association is, what an articles of association is, how does a shareholder agreement plays its role, what are the corporate practices or applications to all of this in due diligence, and we also would analyze a couple of cases here. Okay, so why an MoA or an AoA would matter? What is a memorandum of association? And by the end of the session, I really want you to apply your thinking and understand how to read these documents legally, and how to use it in your practical ways when you are going ahead with any kind of due diligence, or if you're even having to see some companies' documents, what are the things that you should actually go and visit. So this is something I think you will carry once you're done with this session. So majorly, every every constitutional document of any company is actually surrounded with an act. So majorly, any company in India is surrounded with Companies Act 2030, which is the statutory foundation of these documents. So even when you look at the hierarchy of this hierarchically, like the way I have shown it on the screen, Companies Act, I have placed it on the topmost place. Then comes your Memorandum of Association, then your Articles of Association, and then the Shareholders Agreement. Now, when I have kept the Act in the first go, that clearly means that the Act plays the vital role. The Act is going to be the core that one has to look into. In case of any discrepancy or any error or any confusion, you go back to the Companies Act and you see what the Act is talking about. So that is the first and foremost rule in looking at any company's documents. Okay. Next comes the Memorandum of Association. Memorandum of Association, I'll just give you a very small example. Say, for example, there is a building. Okay. Now, when you look at the building, it is standing on a plot of land. Okay. And there must be boundaries to that plot of land. Right. Now, when you say Memorandum of Association, imagine that the Memorandum of Association is the plot of that building or the outside of the building. Okay. Now, you cannot do anything beyond the boundary. Your building cannot have its access beyond the boundary. Okay. So that is how a memorandum of association acts for a company also. Okay. So memorandum of association is like the boundary wall of the company, and whatever happens inside the building, whatever activity is happening inside the building is like the articles of association of your company. Okay. Similarly, when you look at the same analogy, when you take it in a company, you would understand that you cannot go beyond your memorandum. Okay. And your articles of association is something that you're going to work, how it helps you work inside the company is what your articles of association is going to say. Okay. And then you have shareholders agreement. So we will come to this later. Okay. So like I said, the supreme authority is going to be your Companies Act, which is like the foundation of your company. And from where is it getting that authority? That foundation is getting the authority. It is getting from Section 6 of the same Act. So what does the Section 6 says? That in case if memorandum or articles is going against, or if any one of it is trying to prevail, then you have to actually go through the Act first. Okay, it cannot, the memorandum and the articles cannot override your Companies Act. Okay. And then we have some restrictions. That is, you cannot contract out of Companies Act provisions through a customized shareholders agreement or a drafted article. So basically, you cannot breach your Companies Act. That's the crux of this whole slide. Okay. Next. So when I say that, our shareholders, but, if somebody says that, okay, in my shareholders agreement, we have agreed for such a thing. The company has agreed to a particular term or a clause. If something of this confusion arises, the first thing you do is you check your articles. If the articles is also contradicting or anything in relation to your shareholders agreement, then you move to your Companies Act. Okay. So we need to always refer to Section 6 of the Act, which says that, which is the overriding section, which says that in case of any contravention in both MoA or AoA, only the Act will prevail. All right. So what is an MoA? Like I said, it is the boundary wall. What are the characteristics of an MoA? MoA has objects of the company. Okay. When I say the objects of the company, it means that what the company is supposed to be doing. So, for example, if I have a steel manufacturing company where I create steel rods is my major business, and suddenly I want to get into IT and app development or something of that sort. So my MoA strictly would be for manufacturing of steel rods, and I cannot override my MoA and create a new business for me just because it is profitable. That in the same company I start doing, say, application making and developing and software related work and all of that. I cannot do that because my MoA is restricting me. I have agreed in my objects that I am going to be a manufacturer of steel rod alone, or maybe some ancillary activity around it. So I can maybe, in spite of the rods, I start making, say, utensils. Maybe that is part of my MoA somewhere. But creating a software is not, or maybe development into software is not. So I cannot override my MoA when it comes to objects of the company. Okay. So this is the first and foremost thing that you need to understand, that if a particular company's MoA comes to your hand, you have to first see what are the objects of the company. What is the company asking itself to do? What the company wants to do? Okay, which business do they want to create? All right. So the core question here is that it establishes what the company is and where it is legally situated. So another thing so there are a couple of things that will form part of your MoA. And this is defined in Section 4 of your Companies Act. Companies Act has thoroughly given everything. Okay, even the MoA and AoA are part of your schedules in the Companies Act, and from there you pick up the format of each of these MoA and AoA as you apply in your company. Okay, so what does the MoA say? Like I said, it obviously talks about the objects of the company. It gives the name clause of the company, as in what is the name of the company, which is really important. Then you understand where it is situated, what is the jurisdiction. So basically, an MoA would also give you a picture about the jurisdictions of a company. So in case if you have an MoA of a company in your hand, you would first understand what the name is. Yeah. So, for example, say Unit Trust Bank of India was earlier called Unit Trust, but now it is called Axis Bank. Okay. So, definitely in their MoA, this change should be reflecting in their current MoA. They should have clearly written and mentioned that the name has been changed as per the shareholders agreement, and this is what the name is. Okay. Similarly, registered office. So for example, sorry. Yeah.
Please repeat this
Sorry.
name clause.
Yeah, I'm coming to each of it in my next slides. This I'm just giving a small brief.
Okay.
So, for example, is the slide visible?
Yeah.
Hello? Yeah. So, name clause in practice, it looks like the legal identity of the company. Okay. For example, my name is CS Komal Dubey, then that's my legal identity. You would be referring me with that name, right? So, similarly, a company's name is equally important. Is it a private limited company? Is it a public limited company? These are the things you would analyze when you look at the name of the company. Okay. So, legal identity comes from the name clause. You will be able to identify what type of company it is, or is it an LLP? It's not a company, maybe it's an LLP. Okay. So that is something that gives you a picture in the name clause. Plus, in case if there are any changes, if there are any changes in the name, the same would be reflecting in your memorandum. If it is not reflecting, you must question. While doing due diligence, you must question that the company's name is so and so, but why is it not changed in the MoA? The current company's name is changed. Okay. So these are the things that you need to take care of while you're doing due diligences. Okay. Now, the proposed name must not be identical to any existing company. This is one of the statutory requirements for while when you're doing incorporation of a company. This is something that you need to keep in mind, that your name should not be something that is already existing, so that it does not create any confusion. It has to have a the name has to be unique, and it has to give a proper legal identity to it. Okay. Now, you might have two questions here. Say, for example, any company that has a brand name which is different and the company name that is different. For example, uh, say, what example can you take? Maybe for PepsiCo, maybe the company that they are into is totally different. Or maybe say HDFC Bank, that's more relevant to me actually. So HDFC Bank Limited is the name of the company. However, when we talk, we would always identify it as HDFC, at HDFC Bank, or maybe just HDFC, right? So brand name is totally different from company name. Not necessary that the company name and brand name come along together. Okay. So for marketing purposes, our product name would be different, our brand would be different. But for all statutory purposes, and in case if you want to get into any contract or an agreement with the company, you will always have to use the name of the company, that which is provided in the MoA of the company, and they clearly define it that this is the name of the company. Okay. Maybe during the session, I will actually, by the end of the session, I will show you practical insight about one of the companies so that you understand what I'm talking about. Okay. So now next. So this is like a legal identifier for all statutory, tax and contractual purposes. Okay. Next is the registered office clause. Now, registered office clause is again equally important. Why? We definitely want to know where the company is registered. Your place of office is different from your place of registration. This is also something that you should understand. Okay. When you're incorporating the company, there is a form that you file and you place the address of the registered office there. That is going to be your registered office. So ideally, it is deemed that everything, all your matters, official matters and formal communications, corporate filings, like I have mentioned here, jurisdictions of the registrar and statutory notices, everything will fall and come to your registered office. So if a particular client says, no, this is not my registered office, I actually sit there in that location, that is my registered office. So no, that is not, you cannot go by his oral words. You have to check the MoA and understand what the registered office of the company is. So the agreements, when you, in case if the company is entering into any kind of agreement, this is the second thing that you would definitely look into, that where the registered office is located. Okay, and the same address will be used. So even in your agreements, you would see there will be two places. One where you write the registered office in your agreements, and there would be another place where you say communication address. So communication address would be different from your registered, in case if there is a difference. Okay, so that is another thing that you need to check. And so in case if there is any change in the registered office, again has to reflect in your memorandum. There has to be a clear cut mention of the change, and there will be a small line which says that so and so meeting took place and the registered office was changed. Okay, and again this is a full length process in Companies Act and a very separate topic altogether. Okay, so next thing after the name clause in the MoA, the second thing that you understand is the registered office. Okay, next. Object clause. Like I mentioned, that a company has to be very clear as to what his objects are, for what they have incorporated the company, what do they want to do, When they say I want to do a business of say manufacturing bags, so I'm clear about my objective. Okay. Now in that main objects, I can say I will manufacture bags, but initially maybe I'm just manufacturing bags. Later tomorrow when my business grows, I say I want to manufacture suitcases. I want to manufacture say small size wardrobes, or get into varied businesses like that. So my object has to be it has to be broad. At the same time, it has to relate to my core object. So if my object is to make bags, I suddenly cannot say that I will be selling petroleum products with it. I cannot do that. So my object has to be very clear. Now there are 3 object clauses that a company is allowed to keep. 3 objects. And 3 objects can be from 3 different businesses also. That is also possible. However, all of these 3 business may correlate. I mean, ideally should correlate to each other some way or the other. Okay. Now, why is the object clause really important? So when you will look at the balance sheet of a company, what is the first thing you want to know? How much is the income of the company? What is the company earning? How much is the turnover? From where the turnover is coming, right? So you would then understand that the turnover, say for example, the company is manufacturing, like I said, steel rods. And what happens meanwhile is suddenly in last financial year, you see that the income from interest income is increasing. Suddenly an interest income, which is more than the actual main object income. Main object income is selling steel rods, and that should be their turnover. But the income in their interest is increasing. So this should give you a trigger. Why is this happening? Their main object is selling steel rods. Why are they earning so much in interest? If they are earning so much into interest, are they breaching the provisions of an NBFC company? Are they entering into some lending? Are they becoming a lending company? If they are becoming a lending company, is it allowed in their objects? And if they're becoming lending company, then there will be other regulators like your RBI regulation and your SEBI regulations would also come in place then. Then there are so many other compliance issues that they have to think of, right? So that is the reason why. So to understand, where the business is heading, you have to understand the scope of the business. Okay. So that object clause is something that would give you a broader view of what the company is allowed to do. And this is something that is decided by the directors at the initial stage itself. Okay. So this clearly states that this is the primary and ancillary activity. So there are 2 types of activities. I said there are 3 main object clause that you can create. Apart from that, there may be ancillary activities that you can frame into your object clause. Okay. Now, what are ancillary objectives? The very word ancillary means it is going to add to your primary objective, something that will give you a push to incorporate your main objects. Okay. Something, for example, now I have started selling cosmetics. Okay. Now, since everything is now digitizing, everything is becoming online. Now there is a need for me to, buy a software or create one or, something of that sort. So in my ancillary object, I would have somewhere mentioned that I would be digitizing, or I would be using I might be having an online platform for it. So that is my ancillary object. That is actually going to cater to my main object. Okay. Now next, for example, if you want to buy a land. Now buying land is not your core object if you are a cosmetic selling company, correct? However, in your ancillary object, later some point of time, if your business really grows and you really want to buy a land, your ancillary object should mention that you can buy one. Okay. And maybe some bits of it. Okay. Can you explain this objective again? As in what I'm trying to say is that if I have decided that I want to create a company which is going to sell cosmetics today, then my object clause would clearly state that I'm into the business of buying and selling cosmetic or manufacturing cosmetic or anything of that sort. Okay. So this is the core clause of a company to make us understand what the company is capable of doing. All right. If tomorrow suddenly My father says that, "Arey, nahi, nahi, beta, don't do cosmetics. I think apparel business has more scope in profits. Let's get into apparels." Now, I, with the same name company and in the same company, I cannot start an apparel business just like that. I cannot, because my main object says that I am a cosmetic company. All right. So, getting into apparel business would be ultra virus, as in beyond my powers. So, anything that is beyond the powers of a memorandum of association is void, ultra virus. You cannot go beyond the powers. All right. So, this is something that you need to understand and check when you're checking any company, any due diligence you do. First, you need to understand what the object clause is talking about. What are its ancillary objects? In case if they want to buy a land and if they are a cosmetic company, is it mentioned in the ancillary object that they can buy a land? Yeah. Okay. Next. One sec. Yeah. Liability clause. What is a liability clause? Basically, to understand, make you understand what would be the liability of a company or the shareholders or the members. Okay. What is liability? Liability is something that you need to repay back in case if something goes wrong. Okay. In case if the company is, say, if the company is not doing well. All right. Then how much is the liability of the members? So the liability are two types. One is limited liability and the other one is unlimited liability. When I say limited liability, what does it mean? It means that I, as a shareholder, have agreed to buy, say, 10,000 shares of a company for 10 rupees each. Okay. So that means I will be paying 1 lakh as an amount and I will get 10,000 shares from the company. Fine. Now, I did not pay 10 rupees for those shares. I paid, say, 6 rupees for those shares. All right. So that means I am holding 60,000 worth of shares with me, but I have not paid for 4 rupees as yet. 4 rupees is still pending. I'm supposed to pay, but I have not paid yet. So that 4 rupees is the limit up to which I will be, the unpaid amount of the shares that is held by me. I am liable only up to that 4 rupees. Okay. So in case if the company is, say, winding up or anything of this sort happens, anything wrong that goes into the company, my liability will be limited only to the unpaid sum of amount. What I have not paid, I'm supposed to pay now because the company is in crisis and they require money. Okay. So this is what limited shares is. That means it is limited by shares. The company is limited by shares. Next is limited by guarantee, which means that there, say, for example, in the initial part itself, I fix an amount for the company. I say, I agree that, okay, I'm going to give guarantee of 10,000 rupees. When I say I'm going to give guarantee of 10,000 rupees, that means in case of winding up or in case the company and something goes wrong, I will be liable to pay only up to that guaranteed amount that I agreed for. So I agreed for 10,000. I will be liable to pay only that. Okay. So this is your liability clause, which is also a very important clause in your memorandum of articles. Okay. Next is your capital clause. What does a capital clause mean? Now there are, I hope you're aware that there are types of capitals. Okay. One is the authorized capital. Authorized capital is a limit that you create. Okay. For your capital, you create a limit. That limit is called authorized capital. That means what? It means, say, for example, I have created a limit of, say, 15 lakh rupees. Okay. That means my capital can reach up to the limit of 15 lakhs. I can get amount from my shareholders up to the limit of 15 lakhs. Okay. Now, if, for example, I have I have issued shares and I have got money and I have got full 15 lakh rupees in my hand. All right. Now I'm in need of more funds and I'm planning to now ask them to pay me more. I'm planning to issue more shares. How am I getting this money? By selling shares of the company. Shares is the product, okay, that they are selling to all these to whoever wants to buy. Especially if it is a private limited company, it will be limited only to some few people, friends and family types. Okay, so I'm asking them to buy these shares, and I give them the shares and I take the money. That becomes my capital. All right. Now, authorized capital, like I mentioned, is a limit how much I can get. All right. Now, I said I had a 15 lakh of limit. I had asked for money and I gave them shares, and full worth 15 lakhs rupees I have now received. Now, my company is in need of more money. All right. Say, for example, I require 10 lakhs more to run my business. Okay. Now, what do I do? How do I go about it? So the first thing, as a due diligence person, I would do is to go and check my memorandum and check what the capital clause is talking about. Okay, the capital clause clearly mentions how much money I can raise, what is the limit. So if it is beyond 15 lakh, now say for example I mentioned I wanted 10 lakh more, but my limit was only 15 lakh. So what do? Now we have to alter the capital clause and I raise my limit. Okay, so when I raise my limit, I will raise my limit from 15 lakhs, I will raise it to 30 lakhs, because I feel that now I will require more funds to run my business. So from 15 lakh, now I'm raising the capital limit to 30 lakhs, but I'm going to ask for only 10 lakhs. That is my paid up. Okay. So I'm creating a limit of 30 lakhs, but in that 30 lakhs, I'm going to ask only for 10 lakhs. I have already asked for 15, plus I'm asking for 10. So that means 25 lakhs is something that I have as my paid up capital already received. Okay. Now, question being, can I only ask for equity shares? Can I ask for preference shares? Again, that also I have to go back and check my memorandum of association. I need to check in my capital clause, have I created a position for preference shares or not? All right. So if there is a position for preference shares, I have created a limit for preference shares in my MoA, then I can also ask for preference shares from my shareholders. Okay, if there is no limit that is created, then there is no point that I ask them. I will first have to then alter my capital clause, create a limit for preference shares, and then go ahead with asking the shareholders for it. Okay, so second thing in due diligence we do is we need to check what the memorandum of association is talking about when it comes to capital clauses. All right. So what are the things that you see in a capital clause? Amount of registered share capital, division of capital into shares, as in 10 lakh shares of 10 rupees each or 1 lakh shares of 10 rupees each. What is the division? Number of shares, how many shares are there? And number of shares each subscriber agrees to take. So there is a subscriber sheet at the bottom of the MoA that you find. And there you would be able to analyze how much each of them have agreed to buy.
I have a
Initially when the
question
company was
regarding
getting
this.
it. Yeah. Can I are we taking the questions in the end or should I pick up in between?
Ma'am, let's take
Uh,
the questions at the end of the session.
At the end, yeah, because I was thinking I'll just quickly cover it up and then maybe I will come back to these slides again and answer whatever questions you have. Yeah,
Yes, ma'am.
because
Yes, ma'am.
otherwise then it will be difficult for me to complete. Yeah. So yes, so I'm done with capital structure. So this is something that is again a very crucial point in an MoA that you need to understand. So these are very critical things that you need to check the moment you start doing due diligence of the company. Okay. Okay. Now moving ahead with AoA, what is an articles of association? Like I mentioned in my initial example, building a plot is the MoA, and whatever happens inside the building, yeah, is the AoA. When I say inside the building, how it would operate internally, the company, in case if there is a company come, how would it operate? What would it do? What are the shareholders supposed to do? What are the directors supposed to do? Uh, is there a common seal in the company or not? What are the voting rights? If we have a board meeting, what should be the quorum of the meeting? Okay. So all your basic questions and your major questions are answered by your AoA. All right. In case if there are restrictions to transfer of shares, if there are any shares in the company, if it is limited by shares, the company, then what are the restrictions to transfer these shares to somebody else? Okay. These are very basic things that are required. So internal operation, while the MoA looks outwards to the world, the AoA looks inward. So you need to check what's happening inside. Now, you know, question being, is MoA and AoA a private document or a public document? The answer is, it is a public document. Okay. Everybody and anybody can have access to any company's AoA and MoA, be it private limited, be it public limited. It's readily available in ROC. You need to pay some fees and you need to get it. Okay. Now, when I say that AoA is a public document, but the workings in the AoA are very much inward, as in the board of directors would have to follow the AoA, but whatever they decide in the meeting or whatever happens in the meeting is a private affair. All right. Whatever happens in a board meeting is a private affair. However, in case of general meeting is when the shareholders are being involved, then that becomes public only to the extent of the shareholders. So for example, I'm a private limited company. I have, say, 5 shareholders in my company. I call for a general meeting and 5 shareholders come for the general meeting. Then the restriction is extended to those shareholders. The meeting, whatever is discussed in that meeting is extended to the shareholders. But apart from that, whatever happens in the working of the company is an internal matter. All right. Okay. So statutory basis of AoA is Section 5 of the Companies Act, where it clearly gives specific regulations for management of the company. This acts like a rule book of the company. What can happen, what cannot happen, what are the restrictions, what are not the restrictions, and things like that. All right. Now, what does an AoA deal with? What does it deal with? Like I mentioned, it deals with internal management, decision-making procedures, meetings, votings, directors and their powers, shares-related products, transfer of shares, share-related procedures, transfer of shares, governance mechanism, and any other matter that the management finds it necessary. Now, here, when we talk about, in MoA, we spoke about doctrine of ultra-virus as in something that is beyond the powers of the MoA is void. Clear? AoA brings 2 doctrines in place. One is the doctrine of constructive management and the other is doctrine of indoor management. All right. When I talk about constructive management, it clearly mentions that, it is a public document, like I mentioned. Whatever is available readily in public and you can have a look, it clearly says that you as a person should have been aware that my company deals into so and so things and these are the documents that are openly available. Okay, that is constructive management. What is indoor management? And in constructive management, it is clear that in case if things happen, in case if something goes wrong, okay, say for example, if somebody says that if somebody in my company, I deal in steel rod manufacturing, and somebody in my company with my company's name starts selling some other product, okay. Now the constructive management would play its role here and clearly mention that no, this is not. You should have been aware that my company's objects are this. So that is where constructive management plays a role. All right. Indoor management is what, for example, my company decides to borrow, say, 50,000 rupees from somebody or 50 lakh rupees from somebody. Now, it is clearly mentioned in my AoA that for anything beyond the amount of so and so, or any kind of a restriction wherein shareholding, the capital and the reserves, everything together, you cannot borrow, say, beyond 20 lakhs. If that is a restriction that is placed by Companies Act itself, then in that case, anything beyond that means I need to go to shareholders to get the approval and I need to get that borrowings. I can get the borrowings. it as an outsider, I will assume that I will ask you that have you gone, like, is it done? Are the borrowing powers in place for the company? And if you as a company agree, yes, we have taken the approvals and we are ready to, we can borrow 50 lakhs, and you end up buying that, and you end up getting the 50 lakhs, then here indoor management comes into place. Ideally, I as an outsider will assume that you have carried on the board shareholders meeting thoroughly. You have taken the approval of the shareholder to get this level of borrowing which is beyond the Companies Act. I will assume this as an outsider. So indoor management will protect me as an outsider, that I will assume that the company is doing everything as per what the Act and the AoA is talking about. Okay, so doctrine of indoor management helps the outsiders, and doctrine of constructive management actually helps the company itself internally. Okay, so this is something that we need to uh, understand when it comes to AoA. All right. Now, clearly, what's the difference in AoA and MoA? Like I mentioned, uh, objects of the company, constitutional framework of the company, what the company can do is decided by the AoA, MoA, and internal management, how the company will do it is decided by the AoA. MoA contains the objects of the company and AoA contains the management regulations. MoA deals with fundamental matters of the company, and this deals with the AoA deals with the operational matters. All right. And this is governed by the section 4 of the Act, and this is governed by the section 5 of the Companies Act. Okay. Now, drafting of AoA. Now, drafting of AoA, Companies Act has made it very easy for us in the sense that the Act is attached, the section is attached with a schedule. So we will have to refer to Schedule 1, and in the Schedule 1, we have tables there. So, table A, B, C, D, E, I think is MoA related, and from F onwards, it is AoA related. So when you're drafting your AoA, you need to refer the Companies Act, how the Companies Act wants us to draft an AoA. Okay. Now, customization for control, in case if I want to control my AoA, if I say, for example, the Companies Act is saying that, you need to have 7 days, you need to give 7 days of notice for conducting a board meeting. The Companies Act is very clear. They are asking us to give 7 days notice in advance to conduct a board meeting. Okay. Can I entrench? Can I customize this clause? Yes, I can customize the clause. However, I cannot overrule the Companies Act. I cannot say, if Companies Act is giving me 7 days, I cannot say, okay, no, I will give 14 days notice. I can, it cannot say that I will give a lesser amount of notice, or if or something that is restrictive. I can give a stricter regulation towards beyond the Act, but I cannot make it lenient. I cannot make the Act lenient. I cannot customize the clauses in a way that it is going beyond the Companies Act. Okay. So entrenchment provisions can follow, as in it can be restrictive. For example, if I say for example, instead of 7 days, I agree to say I can be more strict. I cannot be lenient. I cannot say, no, I want more leverage. I want 14 days. No, you can restrict it. You can say, I'll give only 5 days notice, or I'll use shorter notice or something of that sort. So that is possible. You can restrict it, but you cannot become lenient on the Act. All right. So you need to always, having said this, it clearly means that you need to go and check your Companies Act every time you come up to all these things. You cannot blindly go ahead with it. Go and check your Companies Act. What is the Act talking about it? Okay. Next, effects of registration. So once you register a company, you have an option to change your MoA, AoA, do all kind of alterations until you have registered it with ROC. All right. Once you have registered your company with ROC, what does it mean by registering the company with ROC? It clearly means incorporation. Okay. Now, when I'm incorporating the company, the moment I incorporate the company, I am registering my company into ROC. All right. As soon as it registers, now I cannot change the MoA AoA. It has become a public document. Now I have to abide to my constitutional documents as is. All right. There cannot be much changes in it. In case if there are changes, if I have to bring some change into any of these constitutional documents, I have to always go back and check with my shareholders. And when I say check with my shareholders, definitely have a shareholders meeting, get approvals in place. And once I get the approval in place, then I will incorporate the same change into my MoA or AoA accordingly. Okay. So these are not merely internal documents. You cannot just say that these are internal documents of the company and that's it. These are binding effect. All the clauses mentioned in the MoA and AoA have binding effect on the company. You can always make them liable for it. You can question them on it. You can check if they are following it or not. All right. So when we are doing due diligence, we need to be really careful with every clause that is mentioned in the MoA and AoA. All right. Now, alteration of, like I mentioned, they can alter, they can change, but it has a proper procedure that is prescribed in the Act for such alterations. You need to always go back to your Companies Act and check what they're asking you to do. Okay. Now, all right, shareholders agreement. Now, what is a shareholders agreement? So shareholders agreement generally comes into place, say for example, if there are JVs that are happening, or if there is a private placement that is happening, or you are bringing any shareholder who was not part of your initial incorporation of the company and now wants to be part of your company. Okay, so then you bring a shareholders agreement in place, and there are a couple of things that you agree in it. Like in JVs, for example, if two companies decide they decide to get into a joint venture, then they bring a agreement in place, a JV agreement in place, and shareholders agreement would be a part of the same JV agreement. All right. Having said that, is shareholders agreement something that will override my constitutional documents of the company, or will it override the Companies Act? No. Like you remember in my first slide, I mentioned Companies Act first, MoA, AoA, and then the shareholders agreement. This clearly means that the shareholders agreement, unless the clauses of the shareholders agreement are incorporated in my AoA, they are not binding on the company. I'll repeat this because this is a very important point. We need to understand that if, say, for example, there are no restrictions in my articles of association with relation to transfer of shares. Okay. My articles of association clearly says that we can transfer shares to anyone. Okay. Now, when I say that I can transfer shares to anyone in my AoA, I will be going by my constitutional document. I am a company. I'll be going by my constitutional document. Now, as a company, I have entered into a shareholders agreement with, say, XYZ company. All right. In that shareholders agreement, there is a restrictive clause on transfer of shares. All right. Now, when I say there is a restrictive clause on transfer of shares, and if I have to, if I am going to, apply that particular clause, can I directly apply it? No. I need to check what my AoA is talking about transfers. If my AoA is clearly saying that there are no restrictions to transfer and you can transfer to anyone, and if my SHA is saying that no, there is a restriction on transfer, my AoA will override the SHA. So in this scenario, we need to understand that our AoA has to absorb those clauses. That means you need to alter your AoA and you need to put those restrictive clauses in you as part of your AoA for it to become binding. Yeah. So if I want them to bind by these clauses, then I need to incorporate this. Yeah. So like I have mentioned here, investor protection and exit. So when I say tag along, drag along rights, and then ROFR and ROFO. ROFR is what? It is rights of first for rights of first refusal. That means such rights are given in your share transfer agreement, in your shareholders agreement. And the other one is the ROFO, which is the right of first offer, which means the offer rights are given first. So what does that mean? That to my existing shareholder, I will first give them the right to refuse. That means if say for example, if I am a shareholder and I receive and I get an offer for, say, I'm ready to buy 10,000 shares of 100 rupees at rupees 100 each. Will you sell it to me? So what will I do? I will go to my existing shareholders and I will tell them that I am having an offer in my hand. He's wanting to buy it for 100 rupees. Are you ready to buy it for 100 rupees? Do you want to match this offer? If he says, yes, I want to buy it, then I actually go to him first. The right of refusal has to be given to him first. And if he says, no, I do not want to buy it, give it to him, then that right has to come from your shareholders agreement. That right needs to be incorporated in your AoA also. Okay. That is what it means. Okay. Your SHA cannot override your MoA and AoA. If your objects of the company are say buying bags and selling bags, then you cannot say that no, I in my shareholders agreement I have agreed to enter into another business. You cannot override your constitutional documents. And if you want to override it or if you want to incorporate it, then you have to alter your documents and incorporate whatever you have agreed in the shareholders agreement into these clauses. All right. So this is also something that you need to understand when it comes to shareholders agreement. Okay. So enforceability gap, does the shareholders agreement automatically bind the company? No. Like I mentioned, for a shareholders agreement provisions, any kind of provision like transfer restrictions, board sitting and affirmative voting, all of this needs to be enforced and has to be incorporated in your AoA. All right. Now next, so this is what I spoke about. So all the VCs and all the Ps, all of them have to understand that whatever they have agreed to in a shareholders agreement, the same needs to be incorporated again in your articles. All right. So all these 3 slides spoke about what I have actually just now explained. So what is the best practice? Standard practice in a private equity or a venture capitalist, what do? They in their deals, they amend the AoA as a condition precedent to closing. Okay. So when they are about to close the deal, this a condition precedent that they apply, and they want them to alter the AoA and put all those restrictive clauses and all the clauses that they have agreed in the shareholders agreement to be part of your AoA. This is something that we need to even remember when we are drafting your shareholders agreement, to place it as a condition precedent. Okay. So when we do a legal due diligence and we read the DNA of the company, what are we trying to understand? If there are any hidden liabilities, if there is any restriction in transfer of shares before merger or acquisition. So in case if there is any investment that is happening, what happens in case of an investment? Are there any clauses that we need to check for? Can they buy a particular land in case if there is a land deal that is happening in the company? Okay. Can they enter into XYZ contract? Is it allowed? Are the boards having the powers to do it? So, such details is something that we need to really look into when we are doing the due diligence of the DNA documents of the company. Okay. And the process, you need to check it clause by clause. You need to cross it with your Companies Act clause by clause. You need to, understand the inconsistencies in case if there are any. And any inconsistency, even the slightest one or the smallest one, needs to be highlighted in your due diligence. That is important. Because the moment you highlight such inconsistencies, it clearly gives that your legal due diligence is actually done well and you are able to give a full fair view of what the opposite company is all about. Should they agree to go ahead with, going ahead with maybe say buying the business or selling the business, or anything of this sort. Okay. So now when we talk about corporate transactions, now there is a separate understanding to what a board power is and what a shareholder's power is. Okay, there are a few restrictions that are given by the Companies Act itself when it comes to restricting the board's power, via section 185, 180 and all of that. And there are certain requirements wherein shareholders needs to come and play their role. Okay, so like I mentioned, any alteration in your constitutional documents, your shareholders have the power to come and agree or not agree to it, give their votes, give their view on it. All right. Similarly, few restrictions are also there on directors in creating charges. Sometimes we give authority to directors via our AoA. Sometimes we agree to it that during the meeting or whatever is decided in the meeting, and we go ahead with this. So these kind of restrictions are also part of your AoA. Some borrowing powers are also dealt with in your Companies Act. There are certain restrictions to it. So you need to always go and cross check your borrowing powers, what the act is talking about, and what is the company actually doing. So you need to cross that up. All right. These are two major case laws that I thought I would discuss. One being the doctrine of ultra virus. This case, Ashbury Railway Carriage and Iron Company Limited versus Ritchie. This clearly was the case was majorly because they were into creating railway carriages, and they entered into some other business which was beyond their objects. So the court clearly mentioned that you cannot go beyond, you cannot ultra virus the MoA. Yeah, you cannot go beyond, you do not have the powers to go beyond your memorandum. So this case is really important when it comes to understanding what a doctrine of ultra virus is. And then VB Rangarajan versus VB Gopalakrishnan. This is also a very important critical case wherein the shareholders agreement had some restrictive restrictive share transfer. They restricted the share transfer. However, the same was not incorporated in the AoA. So the Supreme Court said that since the AoA is the binding document, which is the constitution of the company, and that does not have any restrictive clause as in terms of transferring of shares, therefore the share transfer is pretty valid and is not illegal. So that is, this particular case actually brought into focus that in case of any change in the shareholders agreement, that needs to be incorporated in your AoA right away. All right. So I come to an end of my session. What time is it? So we can actually go ahead with taking questions. I just hope that this brought some clarity in terms of understanding what the constitutional documents are, and every time you do a due diligence, there are some points, certain points that you need to. Okay, I'm sorry, I'm not ending my presentation here. I promised for a company's a document that I wanted to share. One sec. So this is the company I chose today, Cremica. This is a Indore-based company itself. Cremica Lifestyles Private Limited. I hope, is it visible? Okay. So we'll just go ahead with looking at the actual live MoA so that you understand of whatever I spoke today. We'll be able to have a look at it. So this is the memorandum of association. See, it clearly mentions what the document is. So the initial draft of the document itself clearly mentioned. This is the memorandum of association of Cremica Lifestyle. This company is limited by shares. This gives you more understanding of what the company is. It is a limited by shares company and it is incorporated under Companies Act of 2013. So you have the clear name here. Okay. This is the name clause that I was talking about. All right. So whenever say for example, PepsiCo, and you say I am dealing with Pepsi, and in an agreement you cannot put Pepsi there. You have to check what company is that brand registered under, and you need to check what the name of the company is. When you enter into an agreement, you need to check this constitutional document of the company before you start drafting. All right. So name of the company is here. Registered office, it clearly mentions. Like, I'm not able to understand. What are they trying to tell? Ujjwal,
Ma'am,
are you moderating? Yeah.
yes, I
Yeah.
believe what they're trying to say is right now we're only able to see the folder over there. We're not able to see
Oh, okay.
PDF.
One sec. I'm sorry. Okay, one sec. Is it visible now? Is it visible now?
Yes, yes, now it is visible.
Yeah. Okay. I'm sorry. All right. So I'll just start with this again. So basically, what I was trying to say is this is the memorandum of association, okay, of Chemical Lifestyle. So clearly, half the things get cleared in the first three lines itself. All right. You get the name of the company here also, and you get the name of the company here also. Okay. This is the name clause that I was talking about. Okay. This format is clearly readily available in our Companies Act itself in your Schedule 1. And you can go through that anytime you want to. Ideally, same format they follow for all the companies, unless and until there is some kind of an alteration that happens. So, for example, if Cremica Lifestyle earlier maybe they were just Rika Lifestyle, then they would have mentioned here that earlier it was known as Rika Lifestyle. All right. So that also would have been mentioned here in the existing MoA, the current MoA. Okay. Registered office, this clause will make you understand which jurisdiction will the agreement fall under. Okay. Then see, it clearly states here that it is situated in Madhya Pradesh and within the jurisdiction of Registrar of Companies, Gwalior. All right. Now, next, we see the object clause here. So first was the name clause, then was your registered office clause, then is your object clause. When we see the object clause, if you read the object clause, it says to carry on in India and elsewhere the business. Look how broad they drafted. They drafted in a manner. So these are initial documents of your company. Okay. So when we are incorporating a company, we at that particular stage, the client would not be able to understand how big they will grow. But they definitely have some visions, some understanding of how big they will grow. Okay. So that is how, they will incorporate, they will help us. The client himself will help us in understanding what their objectives are and how will they grow in the business and what they are looking into, you know. So to carry on, not just in India, elsewhere. So they have clearly mentioned here that they might even, take it abroad, mm, their boundaries, not just India. Right? To manufacture, contract manufacture, trade, including buy, sell, import, export, all of these words that they use, objective words that they use, and the nouns that they use, and they've mentioned here personal and beauty products, but which is not limited to skin, body, hair care. So they have covered everything here. But Overall, when you read this, you understand that they are into beauty products. All right. This is the main object. Now, if suddenly they decide that they want to enter into business of real estate, can they enter into a business of real estate? Yes or no? Just answer this to me. You are reading the main object of the company. Yes, they cannot enter into a business of real estate. Okay. They cannot enter into a business of real estate. However, can they buy a property? Can they buy a property for themselves later, sometime in their lives that they decide, okay, we have enough funds, now let's buy a land? Can they do that?
Yes.
How are you saying yes? Why are you saying yes? Did you read the whole MoA? Did you read the whole MoA? No. So never ever. Another good thing that you need to understand is we immediately do not answer. As lawyers, we really need to understand and read the document first. Okay? We cannot answer just like that, yes. I need to check the clauses. I need to check my ancillary clause. Is it allowing me to purchase land later? Yeah. So how will I do that? I will have to go clause by clause. Yeah. I think I read it somewhere. One second. I'll just show it to you. I read it somewhere that they have agreed to acquire. See. Now can they buy? Now can they buy? I need an answer, guys. Are you able to understand? In the clause they've written to purchase or
Yes.
otherwise acquire, undertake. Now they can, right? So you read a clause and now you are clear that they can. Property can be anything, right? Immovable, movable. It is a generic word written there. So you can always say, yeah, they can buy land. Looking at this clause, they can. Correct? So this is how you have to do it. This is how you have to read each thing clause by clause. Can they give guarantee to another company? Can they give guarantee? Can they give guarantee to a bank? If they want to give guarantee to a bank, say for a loan that they have taken, how are you saying yes? Did you read a clause again? You have to question me, ma'am. Can you show me the clause? You cannot say yes. You need to read. You need to read the MoA to understand if they can give guarantee. See, clause 33 here, it clearly mentions that you can give guarantee and provide security. Yeah? Got it? So these are the things, every time you enter into a transaction or you read about a transaction of a company, you need to go back to the constitutional document to understand, are they allowed to do it? Does the board have the power to do it? All right. And anything that goes beyond the powers of MoA is void, ultra virus. Okay. Now this like I mentioned that this was the main clause. I showed you one main clause they have in their company, and the rest of it is the ancillary clause. All these are ancillary, or what do you call it, like a objects that are in furtherance to the main object. All these things would help them run the business smoothly. So see, look at the first ancillary clause. They are talking about look at the second one, sorry. See, they are talking about networking businesses. They are talking about outsourcing it. They are talking about programming system and analysis. So all of this they can do if it is covered via the main clause. So say, for example, they are into cosmetic business. They want to run a BPO unit for the cosmetic business. They can do it. If they want to do some recruitment for the cosmetic business, they can do it. If they want to run a consultancy services for this particular business, they can do it. Okay. So this is how you need to check. All these ancillary clauses or all these clauses mentioned here in clause B of the MoA are in furtherance to what is mentioned in the main object. Okay. Now next next we have now seen the name clause, we have seen the registered office, now we have seen the object clause. Okay, after the name, registered office, object clause, and then we have also seen ancillary objects or in furtherance to the main object. After all these three clauses, we then move to our liability clause. What does it say? The liability of the member is limited. When it says it is limited, what does it mean? It is limited to the extent, and the act talks about the rest of the part of it. Okay, it is limited to the extent that is unpaid. Like I gave you an example, right? That I purchased the shares of the company, say for the share price was 10 rupees, but I got only for 6 rupees. I am yet to pay them 4 rupees. Yeah. So my liability is now limited to that 4 rupees. I need to give the, whenever the company is about to wind up, or if they have to, wrap it up or something, I have to repay them what is unpaid. And that is where my liability is limited, only to the extent what is unpaid. Okay, this is my capital clause. I mentioned capital clause. This is my capital clause. I told you clearly that authorized capital is like the limit that you set. So 15 lakh is the limit for them. Okay, and that is divided into, division is also mentioned here, that is divided into, how is this 15 lakh divided? They are dividing 15 lakhs into 50,000 equity shares. There are two types of shares I mentioned, equity and preference. Okay, so they have now divided these shares into 50,000 equity shares for rupees 10 each, and 1 lakh preference shares of rupees 10 each. Which means what? If you total it up, the amount 50,000 into 10 rupees, you get 5 lakh, and 1 lakh into 10 rupees, you get 10 lakh. 10 plus 15, 5 is 15 lakhs. So 15 lakh is the limit of their authorized capital. Okay. So this is the capital clause in a memorandum of association that you need to check. Okay. Next, we move to the subscribers list. So this is the subscriber list. What does the subscriber list talk about? It tells us who's bought those shares. So when I incorporated the company initially, I would have issued some shares. I would have said that, okay, 4 people together, coming together, and they are ready to put money in my company. So I will now give them shares. I will allot them shares for the money that they are putting. So when it is at an initial stage, that is at the incorporation stage, has the company incorporated yet? No, the company is not yet incorporated. That is the reason why we call it subscribers list. They are agreeing to subscribe to it. It has not yet become shares. Okay. So this has not yet become shares. So this is still the subscribers. So now who, let's say for example, if you see this is a public document, you can see Rajat Jain, who is residing at so and so place, is have subscribed to 1,857 shares. Okay. These are number of equity shares that are taken. All right. And the similarly Mohit and all of them. Okay. And you see here there is an international company also as one of their shareholders. Yeah. He's Hunter Amenities International Limited. This is one of their shareholders. Now look at the level of due diligence. What have we understood? That there are 4 individual subscribers in this company, 4 individual subscribers, and there is one international company also who is also acting as a subscriber to this company. All right. Okay. So this is the level of due diligence. And did you see this is signed where? Canada. And this is signed where? Indore as well. So for the individuals, they have signed it in Indore. And for this company, which is a Canada-based company, they have signed it outside. And they have attached the whole thing up. They would have actually sent the last copy to that company, and they would have asked them in Canada to get it attested and then give it back and all of that. They would have done all this. Okay. So this is the MoA of Cremica. Let's now look at the AoA of Cremica. Is the screen visible? Are you able to see the AoA?
Yes.
Okay. One sec. Okay. So this is the articles of the company, articles of association of Cremica Lifestyle. Again, we are repeating the name here. Now we are very sure this is the articles of the same company. Okay. The company is limited by shares and is incorporated under which act? In the Companies Act 2013. This is the preliminary. The preliminary talks about from where it is incorporated. It is incorporated from Table F, first schedule of Companies Act. Okay. These are standard lines that we take from our Companies Act. Okay. It clearly mentions that private companies, save in so far they are impliedly or expressly excluded or varied by these articles and such regulations, and these articles shall be the regulation of the company. So basically, they are these lines are just making sure you understand that this is the constitutional document of the company, and you need to look at this. And in case of any conflict, go to Companies Act first, and you need to anything that is lenient to Companies Act will not prevail in. Okay. Next. So the first thing, if you see, is what like an agreement. In an agreement, there are definitions, right? So similarly, यहाँ पे भी definitions दिया है. Which act are we following? Company का मतलब क्या है? Wherever we are using the word company, what does it mean? And such expressions as may be in the act. So basically, they are always asking us to refer to Table F also somewhere or the other. Okay. Okay. Now, प्राइवेट कंपनी क्या होती है वो यहाँ पे उन्होंने क्लियरली मेंशन किया है कि ये सेक्शन 2 सबसेक्शन 68 ऑफ कंपनीज एक्ट, it is defined there what a private company is, and it has restrictions to right to transfer of shares. So restrictions है and limit the number of members to 200. कुछ नहीं है, repetition of the same section यहाँ पे हुआ है ये. ठीक है. Further down if you go, you will see share capital clause. You will see where it is, what the prohibitions are. You will see clearly mentions कि members कौन होते हैं. यहाँ पे clearly वो mention कर रहा है जो employment में है वो member नहीं है. Members वही हैं जो shares hold करते हैं company के. Okay. और जिनका नाम register में है. Another important thing to understand is the member का definition भी बहुत clearly mention किया है. The moment you say as registered in the name of the member as registered in the books of the company, that clearly means, say for example, share transfer हुआ 1st of August को, okay, and I as a company has time to register the name in my records, and I recorded it on say 10th of August or something of that sort. Then in such scenario, what happens? In such scenarios, in all legal framework, you will become the member from 10th of August, not from 1st of August. Even if your transfer agreement says that you have transferred the share on 1st of August, but from the day your name is entered in my books, from that day you become a member. Do you understand? So what are the legal implications of this? It actually gives you voting rights. You, in case if there are any meetings, you cannot vote if the meeting is before 10th of August. As a new shareholder, you cannot vote. Okay. It also gives you an understanding of, the share transfer in case if there are any. All right. So these are the things that we need to understand. So एक चीज के बहुत सारे implications हो सकते हैं. We need to really think about it when we are doing it. Okay. So authorized share capital क्या होता है यहाँ पे? See, okay, this clause is also very important. What have they mentioned here clearly? If you read, the authorized share capital of the company is as mentioned in clause 5 of MoA, as amended from time to time. See, these wordings are really important. Which means what? Which means tomorrow, if I want to increase the limit, the authorized capital limit, if I want to increase, okay, I will increase the limit. Say, for example, I want to increase it to 50 lakhs. Okay, I can do that in my MoA. However, the same change, in case अगर मैंने ये line नहीं लिखी होती यहाँ पे as amended from time to time, या clause 5 का mention नहीं किया होता यहाँ पे, तो मुझे दो जगह amend करना पड़ता. मुझे MoA में भी amend करना पड़ता मेरे capital clause में, और मुझे एओए में आके यहाँ पे शेयर कैपिटल क्लॉज में भी अमेंड करना पड़ता. So when during due diligence, you need to check what the lines of AoA are for share capital. If it is mentioned clearly here कि as amended from time to time, मतलब clause 5 को refer करना है और clause 5 change हो सकता है और जो वहां पे change होगा वो ही यहाँ पे भी मान्य होगा. Correct? So that is how we need to read this. Next. Further, I will actually take you quickly to share transfer. Okay, so there are a lot of provisions here. Alteration of share capital का provision है यहाँ पे. You need to go back and refer to your schedule 1 table F for a private limited company to understand what are the clauses that come into an AoA. Okay, you need to do that as a homework. So only then this session would be fruitful for you. Okay, so there are a couple of things. These are all standard clauses in an AoA. Generally, there are no changes in it. They just follow it from table F. Unless and until, say for example, अभी यहाँ पे हम देखेंगे share transfer. Okay. Now see, share transfer में initial clauses are standard clauses. Instrument of transfer of any shares in the company shall be executed by or on behalf of both the transferor and the transferee. The transferor shall be deemed to remain the holder of the shares until the name of the transferee is entered into the register of members. Like I mentioned, मैंने यही मेंशन किया था कि रजिस्टर में जब नाम आपका डलेगा जिस तारीख से, उस तारीख से आप मान्य जाएंगे वहां के मेंबर, not from what your transfer deed talks about. Okay, next. यहाँ पे देखिए एक restrictive interesting thing, and apparently I downloaded the right company. So now you'll be able to understand the significance of share transfer. Like we mentioned, like we saw in our MoA, that there were 4 individual subscribers to this company, okay, and 1 international company. Now see what they have done here. Any shares of the company held by Hunter Amenities International Limited shall be freely transferable without any restriction of any nature whatsoever and at its sole discretion. Now, what have they done here? They have given free leverage to their international company, who is one of the subscribers or who is one of the members of shares. Member है वो, shareholder है वो, है ना? तो उसको एक तरीके से एक leverage दिया है यहाँ पे कि you can transfer your shares freely. There is no restriction. If you want to transfer your share to XYZ company, मैं question नहीं करूंगा. Okay, now this is an internal matter of the company. We are talking about the AoA. All right. Generally, in a table F, AoA gives restriction to a private limited company to transfer shares. But here, it is overriding that restriction because ये उनका internal matter है. This is pretty much legal. All right. So this is a very interesting thing in this particular AoA that we saw. Okay. And the board may, subject to the right of appeal conferred by section 58, decline to register. So right of appeal है, लेकिन board के पास restrictions है, they can decline. They can say कि no, I do not want to register this particular. And in only 2 scenarios they cannot. Look at the scenarios that if it is not fully paid. जैसे मान लीजिए आपने 10 रुपए के शेयर लिए, लेकिन आपने पेमेंट 6 रुपए का किया. अब आप कह रहे हैं आपको शेयर ट्रांसफर करना है, तो नहीं, आपको पहले आपके फुल पेमेंट करिए, उसके बाद शेयर ट्रांसफर करिए. अनपेड होगा तो आपको यू कैन नॉट ट्रांसफर योर शेयर्स, तो उसका रिस्ट्रिक्शन कंपनी अप्लाई कर सकती है. सेकेंड इज एनी ट्रांसफर इन विच द कंपनी हैज अ लीन. कंपनी हैज अ लीन का मतलब क्या हुआ? सो फॉर एग्जाम्पल, कंपनी हैज गिवन सम अमाउंट टू समबडी और उनके शेयर्स ले लिए लीन में, 5 लाख रुपए दिए और बोले कि ठीक है तुम्हारे शेयर जमा कर दो, अभी जब तक तुम वो पेमेंट नहीं कर देते हम तुम्हारे शेयर्स अपने पास रखेंगे. दैट इज लीन. ओके, सो एनी शेयर ट्रांसफर. सो अगर मेरे पास उनके शेयर जमा है तो मैं उनका ट्रांसफर एक्सेप्ट नहीं करूंगी. पहले वो पेमेंट लेके आप शेयर छुड़वाओ, फिर आप शेयर ट्रांसफर करो. सो ओनली इन दीज 2 circumstances द कंपनी कैन रिस्ट्रिक्ट. ओके, all right. So this is what it is. And then we have transmission of shares. सब तरीके की चीजें हैं देखिए आप AoA के अंदर. Transmission happens in case of death of any shareholder. How the company will deal with the shares. what will the company do within how many days of receiving the titles या जो भी required legal documents हैं, जैसे ही कंपनी को शेयर सर्टिफिकेट के साथ वो लीगल डॉक्यूमेंट्स मिलते हैं, how will the company then treat, in what turnaround time do they have to do the transmission of these shares, सब कुछ लिखा है यहाँ पे, है ना? So these are all internal things. Forfeiture of shares. Forfeiture is also a very important feature that we talk about. Sometimes it gives the option of forfeiture in AoA. Sometimes they are restrictive. What is forfeiture of shares? मान लीजिए आपने राइट इशू किया शेयर्स का और आपने बोला कि अब आप मेरे को और पैसा चाहिए, इस चीज के लिए फंड चाहिए, तो अब मैं शेयर्स दे रहा हूँ, आप खरीदना हो तो खरीद लीजिए, ठीक है? अब आप क्या कह रहे हैं, नहीं नहीं मेरे पास पैसे नहीं है, मैं खरीदना नहीं चाहती, तो मैं फोरफिट कर रही हूँ इसको किसी और को, somebody else can buy. अब आप इस फोरफीचर को रिस्ट्रिक्ट कर सकते हो, या तो आप एओए के साथ चलें, क्या आपको राइट्स मिल रही है, एओए क्या आपको फोरफीचर करने की राइट्स दे रहा है, कि आपने ए को ऑफर किया लेकिन ए ने बी को दे दिया वो ऑफर क्योंकि ए को नहीं खरीदना, तो क्या ये वाला फीचर है एओए में अवेलेबल? अगर है तो डज द कंपनी हैज द से टू से कि नहीं मेरे को तो नहीं देना भी, वो भी आपको यहाँ पे मिल जाएगा. विद इन हाउ मेनी डेज? ऑल ऑफ दीज थिंग्स आर क्लियरली मेंशन्ड इन द एओए. ओके, सो व्हेन वी डू अ ड्यू डिलिजेंस, फॉर एग्जांपल राइट इशू आपके हाथ में आया और उसमें फोरफीचर हुआ है, तो यू हैव टू गो बैक टू योर एओए एंड चेक क्या इनको फोरफीचर का राइट्स था, डिड whatever they did was it right or not? Okay, so these are the things that your documents talk about, and you need to get back to it every time it all depends on what matter you're dealing with. Say for example, if you're doing a due diligence of the company, बहुत सारे फॉर्म्स होते हैं, ड्यू डिलिजेंस किस चीज के ऊपर हो रहा है, क्या सिर्फ शेयर होल्डर का ड्यू डिलिजेंस हो रहा है या फिर चार्जेस का ड्यू डिलिजेंस हो रहा है या ओवरऑल कंपनी का लीगल ड्यू डिलिजेंस हो रहा है, अग्रीमेंट्स क्या थे इन प्लेस, कंपनी ने किस किस को क्या साइन करके दिया, बोर्ड ने कैसे रिएक्ट किया, क्या मिनट्स इन प्लेस थे, क्या मिनट्स एओए से कनेक्टेड थे. सो ऑल ऑफ दीज थिंग्स आर एब्सोल्युटली मेंशन्ड इन द एओए. जनरल मीटिंग को कैसे कंडक्ट करना है ये देखिए यहाँ पे लिखा है क्लियरली, नॉट गिविंग लेस देन 7 days नोटिस. एक्चुअली रिस्ट्रिक्टिव है ये, पता है आप. कंपनीज एक्ट टॉक्स अबाउट गिविंग, देयर इज अ notification for private limited company that the Companies Act has issued, wherein they give them flexibility to this. तो Companies Act as is apply नहीं हो रहा है, उसका notification भी पढ़ना पड़ेगा आपको to understand. Yeah. So the quorum of the meeting क्या होगी, 2 members होने चाहिए हमेशा. Okay. तो so for example, अगर कोई particular borrowings में शेयर होल्डर का अप्रूवल चाहिए था, शेयर होल्डर आए, मीटिंग हुई, लेकिन कोरम नहीं बैठा, फिर भी आपने बोरोइंग ले ली एज अ कंपनी, इज दैट वैलिड? कोरम
No.
नहीं बैठा, एक ही शेयर होल्डर आया था उस मीटिंग में, तो कोरम नहीं बैठा, हाँ, तो दैट बोरोइंग इज नॉट वैलिड. सो दिस इज द ड्यू डिलिजेंस यू नीड टू डू. You need to check what is the AoA talking about quorum? How many people came for the meeting? Was the quorum sitting? If there was no quorum, how did we pass this resolution? How can you borrow such amount? These are the questions we need to check. Okay? Adjournment अगर होती है मीटिंग की तो क्या होता है, वोटिंग राइट्स रिस्ट्रिक्टेड है कि सबको मिल रहे हैं कि क्या है, कि शेयर्स के ऊपर डिपेंडेंट है, everything is there in the AoA. You need to really dig down deep to understand what it is. And see, these are the first directors of the company. ये भी mentioned है यहाँ पे. So the current directors of the company and the first directors of the company might change. पर ये नाम नहीं हटेगा. Because AoA being a constitutional document, initial incorporation में जो details थी AoA में, वो as is रहेंगी. Unless and until there is change. But your first directors will always remain the people who incorporated the company initially. They will not change. तो ये भी सोचने की बात है, अगर कुछ चेंज आपको दिख रहा है, फॉर्म में कुछ और था फर्स्ट डायरेक्टर और यहाँ पे आपने नया एओए सबमिट किया है हमको, लेकिन यहाँ पे तो कोई और ही दिख रहा है, व्हाई डिड यू चेंज? यू कैन आस्क सच क्वेश्चंस, दैट इज ऑल्सो अ लेवल ऑफ प्री स्क्रूटनी दैट यू डू व्हेन यू अंडरस्टैंड कि कौन थे, लिस्ट ऑफ डायरेक्टर्स क्या थी, हायरार्की क्या थी कंपनी की, किन के हाथों से होके गुजरी है, कितने डायरेक्टर्स आए थे, कितने रिटायर हुए, डायरेक्टर्स के रेम्यूनरेशन के बारे में क्लॉजेस क्या कह रहे हैं, एवरीथिंग. So these are the details that are there in see now managing director, if you see, managing director is not mandatory in a private limited company. Okay. However, Cremica, be having a foreign shareholder in place, they have now added this clause. What have they added? In day-to-day business affairs of the company shall be managed by a managing director, employed by the company. Employed by the company का मतलब हुआ कि उसको सैलरी मिलेगी, तो उनकी बैलेंस शीट्स में भी आप चेक कर सकते हो, उसके ट्रायल बैलेंस में सैलरी दे रहे होंगे उसको, है ना? Who shall also serve as the member of the board. That means he must also be a director of the company, है ना? तो managing director shall have the authority and responsibility to make all business decisions relating to the company. और उसकी क्या अथॉरिटी है, क्या रिस्पॉन्सिबिलिटी है, उसको अथॉरिटी एओए से ही मिल रही है. अब आप ये देखिए कि किसी भी रेजोल्यूशन के अंदर अगर उन्होंने लिख दिया है कि XYZ पर्सन को अथॉरिटी है, या द मैनेजिंग डायरेक्टर ने बिना अथॉरिटी के रेजोल्यूशन में साइन कर दिया है किसी अग्रीमेंट में, तो उसको मेन अथॉरिटी कहाँ से मिल रही है? एओए से मिल रही है. सो इफ यू आर नॉट एबल टू फाइंड आउट एनी रेजोल्यूशन इन द कंपनी which gives ABC person the authority to sign, then that authority might be coming from AoA. So you can actually go back to AoA and check कि authority यहाँ से आ रही है उसको, right? तो अगर रेजोल्यूशन प्लेस में हो या ना हो कोई फर्क नहीं पड़ता. एओए ने अथॉरिटी दे दी है मैनेजिंग डायरेक्टर को. अब कोई भी मैनेजिंग डायरेक्टर हो, पहले XYZ था मैनेजिंग डायरेक्टर, अब ABC हो गया है, तो ABC को भी वो अथॉरिटी मिल जाएगी क्योंकि वो मैनेजिंग डायरेक्टर है. All right. I hope I'm talking so much in Hindi. I didn't realize. I hope everybody is able to understand. So these are the things, you know, everything is written here. We need to just go back and check. और last page जब आप आते हैं इसके this is also important part. This is the you know, the authority given to the subscribers. Subscriber validate कर रहे हैं. ये sheet बहुत important है आपके AoA में कि authority, जे subscribers are validating your AoA and they are saying yes, we agree that this is going to be the rules of the company. This is how the internal management would work. Okay. Somebody was asking for schedule 1 and table F, right? This is the table F that I was mentioning. This is part, I have downloaded it from Companies Act itself. And ये देखिए इसमें first part is MoA. All this is MoA. यहाँ से AoA चालू हो रहा है ना? So this is the table F. It is all given here. इसके बियॉन्ड जब हम जाते हैं या इसके इसमें ही हम एंट्रेंचमेंट्स करते हैं, इसको और रिस्ट्रिक्टिव बनाते हैं, तो हम इसके अंदर ऑल्टरेशन लाते हैं. नहीं तो हम जनरली एज इज यूज करते हैं. जैसे आपने देखा शेयर ट्रांसफर का, जो हंटर कंपनी थी उनकी, उन्होंने वहां पे उनको फ्री राइट्स दिए, है ना? तो वो यहाँ पे नहीं मेंशन होगा. ये तो जेनेरिक ड्राफ्ट है जो आपको उठाना है किसी भी कंपनी के लिए प्राइवेट लिमिटेड. तो अब वहां पे उन्होंने उसको रिस्ट्रिक्ट कर दिया, एक जने के लिए फ्री कर दिया ट्रांसफर. दैट इज पॉसिबल. ओके. So this is the schedule that we were referring to. Here I come to an end to my presentation. In case of any queries, doubts, please feel free to ask. Are we having questions?
Ma'am, I do believe there were some
Yes.
questions in the chat box.
Sorry.
I do believe there were some
Chat
questions
box.
in the chat box. Yes.
Okay. Okay. Here is the chat box. No messages. I don't know why does it say no messages. All right. I received a few. Okay. Please tell practical implications of what I kind of missed it. Since you are a CS yourself, could you please give us an overall guidance relating to CS executive exam? Pretty much a different topic. Like which paper would require extra attention? अरे भैया ये तो हम तो पूरे डिबेट हो गए. Okay, I'll Abhishek. Maybe we can. You can text me separately. Maybe we can discuss it later. You have my. I'm there on the group, so you can definitely text me. Okay. Okay. Sneha is asking, can you explain this objective again? Which I did, right? Practically, why many unlisted or unregistered companies doing this in India, ma'am? I'm sorry, Anuj. Which one were you talking about? If you can explain operation and mismanagement under Section 241 for shareholders' benefit. Operation and mismanagement again is a very different topic, and it requires again, in length discussion about it. AoA would not cover this. I don't. We'll be deviating a lot and we'll be confusing others. तो आज जो हमने पढ़ा है पहला हम उसका refresher ले ले तो ज़्यादा अच्छा रहेगा. Anuj can contact me again for any other query.
Ma'am,
Alright?
operation
But I
and
couldn't
mismanagement.
understand.
Ma'am, operation
Sorry.
and mismanagement related to ma'am companies, directors or shareholders only. I'm talking about.
So exactly my point, Anuj. ये बहुत separate topic है altogether. See, operation of mismanagement, like I mentioned in one of my articles, is clearly you can read. We've actually mentioned it in one of the blogs recently, है ना, Ujjwal? So
Yes,
it
yes.
is a shareholders dispute की तरह से हम बात कर रहे हैं यहाँ पे minority shareholders की rights के बारे में बात किया गया है how it is dealt with. तो उसके बारे में in length हमने हमारे blog में डाला है अनुज. If you can go back to our Sharma Camp blog and maybe you can refer there, you'll get an answer to the queries. Beyond that, if you want anything, then you can contact me definitely. Because operation of mismanagement is a separate topic. आज हम discuss कर रहे हैं MoA AoA. So I would want to restrict myself to it so that I don't confuse others in the group.
I'll share a link to
Yeah.
that blog on the chat.
Yeah.
So
Yeah. Do that, please. Yes. Okay. What are the major concept of changes were made in Companies Act 1956 to from 2013? So major क्या हुआ था? A lot of board powers and restrictions in section 180 से लेके 186 तक, if you see in Companies Act, these were the major sections that were altered in the new Companies Act, and that had a lot of implications in the sense that पहले freely they were giving guarantees freely. It was all not very restrictive as such. फिर जब से ये clauses के अंदर section के अंदर जब restriction आया तो काफी companies ने हमने देखा कि उन्होंने अपने constitutional documents में उस section के related incorporate किया, because see constitutional documents doesn't change and we were not mandated to change the document. You're not mandated to change your constitutional document. Even if the act changes, you can just say you are now onwards going to abide by Companies Act 2013. लेकिन ऐसे काफी क्लॉजेस थे जो कि एओए को ओवर पावर कर रहे थे कंपनीज एक्ट के अंदर. So those were the sections that a lot of companies actually ended up changing their constitutional documents to come in line with Companies Act and to remove those restrictive clauses that were actually restrictive them to a lot of things. When you see board powers, section 180 से लेके section 185 तक, if you have a look, loan to directors and all of that, those were the clauses that were majorly affected. तो उसका change काफी companies ने अपने constitutional documents change करके उस change को जो है neutralize करने की कोशिश की थी. This I'm talking about in 2013-14 around.
Yes, ma'am. Thank you, ma'am.
Okay.
Ma'am,
In case
my first question was about the companies are making shell companies, and in the name of shell companies, they are taking input tax credit fraudly and from the government, and government imposes them and banning them for the lifetime. Ma'am, why they are not able to operate in India and they are happy to operate outside India because of the policies and
no,
made by the government in India, ma'am? What?
you would be very happy to know that MCA, as in our Ministry of Corporate Affairs, become pretty restrictive that way, and they have come up with systems in place wherein they are able to identify couple of companies, है ना, और उनको क्योंकि अब the information पहले नहीं थी ये चीज अनुज, अब क्या हो रहा है कि अब they are asking for intricate datas, and when they are asking for intricate datas, then they have created systems in place. अब AI, even MCA भी AI use कर रहा है कहीं ना कहीं, we feel. So they are able to now track those companies which are shell companies. Okay. And they're able to bring in that in place, but that is going to take some more time. All right. Another thing is that if you have incorporated a company and if you're going by compliance, let's come to this as a a generic discussion. If you have incorporated a company, you are doing all your compliances in time. You are following your MoA, AoA constitutional document. Government is giving you ease of business ka funda and they are giving you GST and everything and everything and everything and you're doing it. What is the problem? Will you be able to find out if they are sham or if they are a shell company or anything of this sort? Unless and until you really do their financial checks and unless and until you really get down to due diligence of trickling it down कि कितने layers की company बनी है या नहीं बनी है या ऊपर कितने layers है या ये funds कहाँ से आ रहे हैं, those kind of financial checks only will help you understand this, if it is a shell company or not. But on the face of it, everything, those who want to really do something like a shell company thing, they follow compliances. They ensure that the company is doing fine when it comes to compliances, that they do not get caught. So that is also something that we need to understand as a fact.
It is connected to corporate veil, ma'am, anywhere.
Sorry, it is connected to?
Ma'am, unveiling of corporate veil, like corporate veil, if you are talking about anywhere, it is seem to be like
Even
this.
yes, so that happens. So that exactly my point. So now when I said that MCA is becoming active, I clearly mean that they are coming up with so many notifications. Now you're supposed to give them 2 layer below and you are supposed to give them ultimate shareholders also. So जब आप वो करते हो, जब आप ट्रिकल डाउन अप्रोच और ट्रिकल अप अप्रोच दिखाते हो कंपनी का, तो आपको पता चल जाता है कि पैसा कहाँ से आ रहा है और कहाँ जा रहा है. Who your subsidiary companies are, how many layers do you have. They have now included associate companies, they have now merged consolidated balance sheets चाहिए अब ministry को. When I say consolidated balance sheets, उनको subsidiary की consolidated balance sheet चाहिए, associate company का वहाँ पे पूरा data होना चाहिए. तो आपकी एक स्टैंड अलोन बैलेंस शीट अलग चलती है, आपकी एक कंसोलिडेटेड बैलेंस शीट अलग चलती है, तो जिसमें आप सारी कंपनीज आपकी जितनी भी हैं, तो जो अगर आप होल्डिंग कंपनी हुए तो आपको आपकी सारी सब्सिडरी कंपनीज की बैलेंस शीट्स को मर्ज करके सिंगल बैलेंस शीट देनी है कंसोलिडेटेड. So these are the steps that the government is taking to understand, how the money is flowing, how the companies are routing it, what are the companies, कहाँ से आ रहा है पैसा. So these are the ways that they're doing it. It is coming. The compliance is becoming stricter day by day, and it is coming. We can see the change from what it was from when I initially started and from where we have reached. Yeah.
If the company, if the
In
company
case
was
of
incorporated, if the company
yeah,
was
Kajal, right? I'm
incorporated,
actually was looking at your
yeah,
question only. Yes.
if the company was incorporated under 1956, now it is converted. Suppose it was incorporated as a private company, okay, under 1956. Now it is converted into public company under Companies Act 2013. So what will be the impact in the MoA and AoA? Major impact that we should follow, we should check.
So major impact would be, see, restriction of members, है ना? Now you are a public limited company, so there is no restriction of members. Private limited के अंदर there is restriction of members. आप 200 shareholders से ज्यादा ले नहीं सकते, है ना? तो अब आप public हो गए हो, तो you can now issue shares to public. Okay, that is one major change. Another major change being definitely the transfer of shares. पहले आपका restricted था, private limited से आप permission लेंगे और वो आपको restrict कर सकता था. अब आप पब्लिक कंपनी है तो अब आपको ट्रांसफर ऑफ शेयर्स थोड़े फ्री हो जाएंगे आपके लिए. तो दोज आर द मेजर चेंजेस. उसके अलावा आपकी शेयर होल्डिंग, आपकी डायरेक्टर पब्लिक कंपनी के अंदर, प्राइवेट कंपनी में 2 डायरेक्टर्स, पब्लिक में 3 डायरेक्टर्स मैंडेटरी है. तो दीज आर द चेंजेस. तो ये सारे कन्वर्जन के बाद आपको ये सब चीजें इंश्योर करनी है कि अवेलेबल हो, राइट?
And the name will also be changed, right?
नेम डेफिनेटली प्राइवेट लिमिटेड से पब्लिक लिमिटेड हो जाएगा, आपका नेम क्लॉज बदलेगा, आपके एमओए के एओए के क्लॉजेस भी बदल जाएंगे। काफी सारे लिवरेजेस जो प्राइवेट लिमिटेड को मिलते हैं अब पब्लिक लिमिटेड हो जाएंगे तो हम उनको नहीं मिलेंगे। रिस्ट्रिक्टिव क्लॉजेस बहुत सारे आ जाएंगे बिकॉज यू आर अ पब्लिक लिमिटेड कंपनी नाउ, सो वी हैव टू एक्ट रेस्पॉन्सिबली। तो उस हिसाब से आपका टेबल भी चेंज हो जाएगा, मतलब आप यू विल हैव टू इनकॉर्पोरेट ऑल दैट। ओके, so
Okay.
whole of your MOA AOA will change. Yeah.
And in case of increase in authorized share capital, suppose a company has increased its authorized share capital from 2 to 3 times. Okay. Now in the
Hmm.
MOA, we have to clearly mention regarding all the changes, like starting
Yes.
to the end.
Yes. No. No. You will have to mention all the changes
Okay.
from starting till till end, till whatever it is current, and that has to continue. So see, these are your constitutional documents. You cannot bring a lot of changes in this, है ना? तो जब हम एक बार डाल देते हैं कोई चीज उसके अंदर से, फॉर एग्जाम्पल नाम बदल गया कंपनी का, सो यू से दैट प्रीवियसली वी वर फॉर्मली नोन एज सो एंड सो, right? You either put it on the head of the company or you mention it below with an asterisk above, but you have to mention कि हम पहले ये बुलाए जाते थे, अब से हमारा नाम ये हो गया है ना? पहले हमारा ऑथराइज कैपिटल ये था, इस पर्टिकुलर डेट को शेयर होल्डर्स मीटिंग में अग्री किया गया कि अब हमारा शेयर कैपिटल ये होगा। दैट इज हाउ वी चेंज। ऑल राइट, सो ऑल द चेंजेस विल कैरी ऑन। वो आपके these are life documents of the company, they until the end of the company, मतलब जब तक आप लिक्विडेट नहीं कर लेते कंपनी को, ये आपके डॉक्यूमेंट्स नहीं बदलेंगे, ये आपको कैरी करने पड़ेंगे एज इज। ओके, ओके, अथर कुछ कहना चाह रहे हैं, बट एक्चुअली डिपेंड्स ऑन द कंपनीज एक्ट, द प्राइवेट कंपनी हैव रिस्ट्रिक्शन ट्रांसफर ऑफ शेयर्स, पब्लिक हैज राइट टू फ्रीली ट्रांसफर, दिस डिसाइड बाय द कंपनी। अच्छा, ये आपको ही जवाब दे रहे थे शायद। ओके, सॉरी, बीच में कुछ और एक्सप्लेनेशन, ये क्या, व्हाई डिड वी टॉक अबाउट प्रॉमिसरी एस्टॉपल हियर? आई डिड नॉट मेंशन इट एनीवेयर।
Ma'am, I have asked about that. What is the concept of promissory estoppel? It is asking one of our exams.
अच्छा, ओके,
In my objective
ओके,
type
नॉट
exam,
रिलेटेड टू माय, ओके,
no. Yes.
ओके, उज्जवल हैज आंसर्ड।
If you have any knowledge about it, please give us like.
I think Ujjwal has answered. Okay.